Hello, everyone. This is Brian Jackson, an attorney and also your host of the podcast Lawed Up. I really wish I would have had a podcast like this before I went to law school, which is part of the reason why I'm doing this, but also the other reason, even if you're not going to law school, want everyone to better understand how the law works, how to analyze the law, the legal concepts, because it really is a completely foreign system, the legal system. Before I went to law school, I was working a job and I was trying to find as much stuff I could find on the internet. That was back in the day when there wasn't as much content. I couldn't find a single podcast like this at all. And most stuff I was reading on the internet said, well, no, don't worry about it. Just take a break now, a mental break now, and learn all the stuff when you get to law school. And I'm not necessarily a fan of that because how foreign these concepts are. If you can get your head wrapped around some of this stuff before you get to law school, the better, I would say. And part of what I'm doing with these podcasts is giving a breakdown of what they teach you in law school, especially first, second year in law school, really the stuff that's on the bar exam. And so this is a big one, is torts, which a lot of people haven't even heard this word before. Tort, what is a tort? And one time I was a paralegal before law school, and all of us paralegals one time approached one of the attorneys in the firm and we asked, hey, what's a tort? And he took out a rubber band and pulled it back, and then I can't remember if he shot it at someone, and he was like, that's a tort. And that wasn't a good example at all on what a tort was. That's a small sliver of the tort, but it's really a bigger thing. And so my purpose here today is to better explain the law of torts. So what they teach in torts class, like in, I would say 75% of the class, they're talking about negligence and the reasonable person standard. And so essentially you have common law in the UK. Before the United States even existed, you had these judges determining liability towards one person and another person injured another person. So kind of like your personal injury stuff. And that's kind of really broadly what torts are these legal duties that we owe towards people. And some of the duties have just come out of judges' decisions and common law and isn't necessarily anything that's in a statute per se. It's just how judges have interpreted it. But then there's others, some civil duties, liabilities we owe towards one another that are in statute. So they're not criminal stuff per se. They're lower than criminal. I mean, some of them kind of run into criminal activity, like assault and battery. But the definition of assault and battery is different in the civil world than the criminal world. But yeah, it's usually injuries we cause to people and compensating them monetarily for the injuries we cause to them. That's usually the tort. And generally speaking, we all owe a duty to one another to be the reasonable person. So that's the standard that we all have, whether or not it's in a statute or not. Generally, we all owe a duty to one another to act reasonable. We're all supposed to act reasonable. And then what the analysis is, if there's an issue on if somebody deviates from the reasonable standard. If somebody doesn't act like a reasonable person. So in a tort, what attorneys are looking at first is, did somebody deviate from the standard of care as a reasonable person? What would a reasonable person do in that same scenario? So say I'm in a car. I mean, most torts are car accidents. Say I'm in a car and I'm talking on the phone, and I'm going to switch lanes and I don't check my blind spot, and I smash into the person in the next lane and they're in my blind spot. So I owed a duty to that person that I smashed into to be a reasonable driver. So what would a reasonable driver do in this circumstance? Reasonable driver wouldn't be talking on their phone. They would be alert. Reasonable driver, they've been taught to check their blind spots. So 2 whammies on me to claim that I have deviated from the standard of care as a reasonable person would do in the car. And so because I've and then the other part is that you look at is, are you the proximate cause of that person getting smashed? Was it me that smashed the car, or was it something else that had to do it? So proximate cause, the big case that they do in torts is there's it's like in the early 1900s, and there's this lady that I can't remember all the string of events. It's one of those crazy kind of Lego things where she did something, or the train did something, and something did something, something did something, something did something, and it caused injury to her. And famous judge Justice Cardoso penned that opinion, and pretty much claimed that there were so many things that happened. Like, I think it was like sparks from the train caught some hay on fire that did something else, And so I think she sued the train company, and Cardoso said, well, the sparks, yes, but it wasn't per se the proximate cause of your injuries. You can't find the train company liable. So, but in my scenario with the car accident, there's really no question that me smashing into the side of a car was the proximate cause of the injuries. Proximate cause comes more into play with medical issues. So say somebody had a hurt shoulder. Say I smashed into this person in our first scenario, and they had a hurt shoulder, and maybe some tendon issues or whatever, and they've already had shoulder surgery on it prior, and still having shoulder issues, and I smash into them, and then she makes a claim that I hurt her shoulder, then proximate cause could be, that comes into more importance here, because the question is, was I the proximate cause of causing injury to the shoulder, or was it a pre-existing condition? And that's really what a lot of defense attorneys focus on, and they get their medical experts to claim that no, it has nothing to do with this injury, and big back and forth of that. So that's where proximate cause, and so you have to prove medical causation, that this medical condition was caused by the car accident. It wasn't caused by pre-existing or degenerative condition. And then also, and that also comes into damages, and we'll talk a little bit about damages. That I had a whole class that I took in law school related to damages, but you also have to prove that the damages are reasonably related to the accident as well. So what damages you could recover is, back to the car accident scenario, if I cause some serious injuries to somebody and they can't work for an extended period of time, say 3 months, then I would be on the hook to them financially for 3 months of wages. And then also, one thing so we talked about the hurt shoulder. If they could prove that some medical injuries was because of the car accident, I would be on the hook for their medical expenses. And it's not just, and when I talk about these injuries too, it's not just past, it's past and future. So past and future medical expenses. And so for future medical expenses, you usually need an expert witness, like a doctor, saying that yes, these injuries have occurred and they need this additional care as well in the future, to determine future medical damages. So they need more physical therapy, more medication, stuff like that, to determine future medical damages. And then also future lost wages. If they've lost 3 months of work and it's expected that they're going to lose a year more work, or they can't work at all for the rest of their lives, then you could be on the hook for future lost wages as well. So if you cause a really serious accident and that person can't work anymore and they're in their 20s and retirement is like 65, you could be on the hook for over 40 years of wages. So those damages can become significant. And then also, like, if I totaled the car, if the car has been damaged, I have to pay to replace the car and or for damages related to fixing the car and or car rental fees, stuff like that. And then the other big damage too is emotional pain and suffering, physical and emotional pain and suffering. So say I hurt someone in a car accident and I caused them a bunch of pain, physical pain. The law compensates someone for having to go through that pain. And what's tricky with that is there's really no set algorithm on how much that is worth. And it really is something that you just take to the jury, and the jury has to decide. And it's usually on a per diem basis. So how much is the pain worth per day that you present to the jury? And again, it's past and future. So if they've suffered physical pain and future pain, you can recover both. And so a jury would have to determine, this is worth 100 a day, 200 a day, 300 a day. And that's really where the damages get expensive, and that emotional pain and suffering can end up being more than medical expenses and lost wages. Usually insurance companies, how they calculate it is typically they take the amount of actual damages and they times it by 3, or attorneys, when they're assessing a case, they times it by 3. And so usually emotional damages are 3 times the amount of actual damages. And there's also punitive damages in some tort cases. Usually they have to be authorized by statute, and they usually have to be intentional torts, where you had a mental, you mentally wanted to, like, if there was a statute in a state that said that I could recover punitive damages for intentionally causing harm to someone, if I intentionally wanted to smash into that car, I could technically be on the hook for punitive damages. And so what punitive damages are, it's like a penalty for doing something wrong, and to deter you from doing that again. And punitive damages are the highest amount of damages you can recover, because typically how they can be calculated is you can take the amount of all the damages we already talked about and then times that again by 3 or 4. And so that's where punitive damages can get really expensive. But I always tell clients not to think about punitive damages in assessing a case, and don't think that you're going to win a lot of money on punitive damages. And also too, it's up to the judge. The judge is the one who decides punitive damages and the amount. And again, it's not really compensating you per se for your damages. And when you assess a case, an attorney assesses a case. When I assess a case, I don't assess it on, oh, I'm going to get $1 million off punitive damages. I don't think of it at all. I look at the actual damages. So if the damages are $50, you think you're going to get $1 million off punitive damages, don't think about that. Think about your actual damages in assessing your case. And also in Utah, at least, punitive damages, you get the first $50,000, and then after that you split half of the amount with the state, and so half of the amount goes to the state anyway. And also if the judge looks at how much a person can even afford to pay it. Like, so if it's just a single person that doesn't have a lot of money, there might not be a high amount of punitive damages, or small business. If it's a really big business, then that's where big punitive damages can come into play, because they can afford it, because it's not, I mean, they look at too on if this is like a crippling, like crazy amount and you can appeal crazy punitive damages amount, or if it's really reasonable and is more like a fine and not like, torpedoing your future. But also in assessing cases, attorneys think differently too when they look at cases than a normal human, because something really terrible could happen to you emotionally or physically, but attorney might look at it and say, I'm not going to take this case because you haven't suffered a lot of damages. So maybe you do have a case, maybe you can prove that somebody deviated from the standard of care, and that deviation is called negligence. I was negligent in deviating from the standard of care. But even still, if what are my damages? How much is the case worth? So it's one thing like proving the facts, but then the other part is how much is the case worth? And if your damages are only $50 or not that much, then an attorney might not take it on. So one thing too is looking at assessing the damages. And going back to the car accident thing, in the crazy part about it is there are a lot of police officers who think they have to play judge at the time of the accident, and usually police officers come to a scene of an accident to kind of help facilitate and do the investigation, but some think that they need to figure out who is at fault right then and there, and they don't have to, but a lot of them do, and a lot of them do it by issuing citations saying, like a citation like following too closely or failure to yield, which are kind of arbitrary. And so that's why some attorneys say don't say anything at the scene of the accident, so you're not found liable. And the reason why you don't say anything, because under the rules of evidence, there's some things that can't come into court that has been said out of court. So out of court statements, hearsay. There's things that can't come in live testimony at a trial. That is hearsay, but there are hearsay exceptions. And one exception is an opposing party statement or a statement against your own interest. And so if you go to the person that's involved in the accident as well, and you go up to them and say, oh, I'm sorry, I didn't see you, or I was on my phone or whatever, then that is evidence that can be used, and it's also an admission of guilt that can be used against you to make it pretty easy for them to find you at fault. And maybe there was some issues, but things happen so fast you may not have thought about other factors that may have mitigated your fault, or there may have been some issues with the other driver, but the other driver may not have admitted that. You may have learned that maybe they were on their on their phone, or that they were speeding or something. So that's kind of the reason they say don't don't talk about it per se to the other person or admit fault. Maybe you can still, you still need to talk, you still need to exchange insurance information, but you don't necessarily have to talk about the scenario with them at that time. And then also, if you do get a traffic citation, and sometimes it has sometimes with traffic citations, you can just pay the fine and not show up to court. But if you pay the fine, that can be, that in most states, a lot of states, criminal traffic courts is an admission of guilt. You're admitting to it, you're paying the fine. And so they can use that as well to claim that you're liable. So if you just say, I just don't want to go to court on this failure to yield, I don't have time, that could make it more tricky for you to claim that you're not at fault in a personal injury situation. So, and if there's a lot of money at stake and it becomes a serious accident, then it may be good to get an attorney to help you fight that simple traffic court ticket to help you in your other case. And also, that's why it's important to have car insurance, and why car insurance is required, because of how much people can recover in tort cases. And it also protects you, especially if you have a lot of money and have a lot of assets, and it's a $3-5 million case, and you only have a $25,000 insurance policy. They can, if the insurance policy doesn't cover everything, then they can go after you personally. So that's one thing to think about too, as a practical matter, is, are my insurance policies properly protecting my assets? Because that's what attorneys look at too, is maybe you have $5 million case against somebody, but maybe there's no insurance policy, and maybe this person is homeless, or maybe you got beat up by a homeless person. So attorney might say, sorry, I'm not going to take this case because, we could get a $5 million judgment, but you still might not see a dime. So attorneys, they go after big pockets. They look for insurance policies, homeowner insurance policies, if it happened at home. Look to see if somebody has assets, or if it's a company, they look to see if it can involve a company. They look to see if they can get a company liable. So those are practical things that attorneys look at in analyzing cases, and whether or not you have a good case or a bad case. And then so you have that reasonable person standard that we're all held to, and sometimes in some scenarios you did act as a reasonable person and you aren't liable. So back to the police officer situation, trying to play judge, there could be a situation where nobody deviated from the standard of care, and then nobody's at fault, and both parties pay their own ways. But that can depend on the state too. There's some states that say, like, if you're 10% at fault, so first a jury would have to determine whether or not you even deviated from the standard of care, and then they have to determine a percentage of fault. Were you 10% at fault, 22% at fault? And in some states, if the person is less than 50% at fault, so if I was less than 50% at fault in a car accident, then that other person can't recover at all. But then in other states, if you're just 5% at fault, then you're on the hook for 5% of that person's damages. So it depends on the state too, on finding fault and how they figure out fault. And then there's other specific torts too that can be more codified in statutes, giving more specifically the elements you have to prove. So that can be torts such as assault and battery. So assault in the criminal world is different than the civil world. Assault is just putting someone in apprehension of harm in the civil world. And then battery is I actually punch you. And so if I cock back my fist and I put you in apprehension of harm, that is assault, and you can recover for that apprehension of harm. And then battery is I actually punch you and you can recover for the physical pain that you suffer from as well. Um, and and usually in assault there has to be a mental element, like the intent to do it. I intentionally wanted to punch you. And if I didn't, if I just, was happy and went like that and punched you, then it may not be an assault claim, but it could still be the reasonable person negligence claim. But the difference is you, in some intentional cases, you can recover punitive damages, but in a negligence one, you may not recover punitive damages. So that's the difference there. But it's definitely a higher burden to have that mental element and harder cases with intent. Like there's cases like intentional infliction of emotional distress, and those are hard cases, and usually you have to prove that what somebody did was outside the bounds of decency. And there's a lot of judges who think that we're indecent people, and so you can pretty much get away with a lot of indecent things that are still inside the bounds. So those can be hard cases, intentional infliction, but there's also negligent infliction of emotional distress. So you can still have an easier case with negligence, but still you may not be able to recover punitive damages. But also too, just so you know, there is this chasm, this hole called the workers' compensation exemption, where if you're an employee and you get injured at work by your company, you may not be able to go after your company for these big, high money cases, because essentially most states have law that says that if you're injured at work, you have to go recover under workers' compensation. And the types of damages you can get under workers' compensation are a lot less. But there still are exceptions where if you can prove that the company, in some states, if it's an intentional tort, you can get around that exception. But again, those are still harder proof cases to prove, and or if your employer directed the injury, some cases will let you recover the full amount of damages instead of the smaller workers' compensation damages that you could recover. Other torts that fall in the realm that they talk about in a lot of torts classes are defamation of character / slander. They're pretty much the same thing. Slander is just verbally saying something about someone, and then defamation is usually publishing. And defamation is essentially saying something that's false about someone that lowers their reputation in the community. So if they say something that's false, and that false statement makes them lose their job and or makes them lose business and relationships or something, you can recover for that false statement. But it can't be a statement like if I'm just with somebody one-on-one and they say a false statement, that can't be slander or defamation. It has to be made toward a third party. So if they say something and my boss is there and it's false and my boss terminates me for that, that could be a slander case. And slander is just something said verbally that's false. And then defamation is something like in a newspaper, social media, on the news, that's false, that's published. And some states have protections for the media where it's a little bit harder to go after the media. And then also the U.S. Supreme Court came out with a decision saying that it relates to the First Amendment, which in my mind doesn't make sense because First Amendment relates to what the government can't do, and they're applying this to non-government people too. But it pretty much says that if you're a public figure, whether or not you work for the government, if you're like a celebrity, you're supposed to have thicker skin than other people. And so if somebody says something false against you, you usually have to prove a higher standard. One of those intentional torts, you have to prove actual malice, that they actually wanted to cause harm to your character. Whereas if it was just, a false fact and they didn't know it was false, they misspoke, then you may not be able to recover. But if it's just two private people, and somebody says something that's false, you can recover against them, and you just have to prove that it's false and that it was published. So either communicated to a third person, like my boss, or communicated to a newspaper. And then there's also false light, which is a little bit a lower standard than defamation. Maybe it's not necessarily something that was said that was false, but just the way it was construed put me in a false light that caused damage to me, that made me lose my job. Like a video that didn't show full context, or communication that didn't talk about the full context, or making somebody thinking I was doing something, being somewhere where in context maybe I was there, but really wasn't there for that reason. So you can recover for false light as well. And there's also so those are kind of the privacy torts, and there's other privacy torts like invasion of privacy. And if someone's coming into my house, taking pictures of me, you could have an invasion of privacy claim. And usually, it has to involve something on your premises, because if you're out in public, usually it's fair game. So the privacy usually relates to just your home and or business. And then also misappropriation of name or likeness. So if I use a celebrity's name and I don't have a contract or an endorsement from them and I make money off them, then I can get sued for that as well. And that kind of goes into the privacy, kind of runs into trademark too, but more in the privacy realm. And then also the other big one is products liability. And every state has different products liability statutes, and they're usually not the same. They're way different. Utah has one that's actually very consumer friendly. And then there's surprisingly, because it's a conservative state, but then there's other states that are more business friendly, and it's harder to make a claim, and you usually have to prove that the company was negligent in making the product. So if it's just a product that came out and they weren't negligent, and maybe harder to recover. But in Utah, you just have to prove that it was unreasonably dangerous to the consumer, that the consumer, a danger that the consumer wouldn't appreciate or expect. So if it's something like a lawnmower and someone gets their foot cut, I mean, that's usually in a danger that a consumer would expect. But if there's something like faulty wiring or something, then under Utah, you could say that the faulty wiring, a consumer wouldn't expect faulty wiring, and so could claim that that's unreasonably dangerous. So that's kind of the breakdown in general, what a tort is. It's just duties we owe to one another, and damages and liability. So if there's but that's, so when it comes to personal injury attorney, that's really what type of stuff they do, what they focus on. A lot of personal injury is focused on car accidents, because everyone has car insurance and policy, and so it's just easier to recover under car insurance policies. But that's it for me with this episode. Lot Up. Thanks for listening. Like and subscribe for more info related to law, policy, and we'll talk to you again. Take care.